I'm not sure if you can hear me, but I can't hear you, so I'm going to work on it on this end.
I can hear you, Commissioner Plant, but I can't hear Chair Blink.
How about
Oh,
now?
maybe that was the problem.
Can you hear me now?
Yeah.
Thank you. My name is Eric Blank, and this is the Commissioners' Weekly Meeting for October 22nd, 2025. Before we vote on the consent agenda, I'd like to make one change on proceeding, where is it? Number 24A-0547E, the Public Service Company of Colorado Distribution System Plan. I'd like to start the Commissioners' deliberation meeting tomorrow, October 23rd at 1:15. I assume that works for you, Commissioner.
It does. Thank you.
Yeah. With that, Commissioner Plant, with that one modification, which hopefully we'll notice on the calendar, are you ready to approve the consent agenda?
I am.
As am I. With that, let's go to discussion item proceeding number 25A-0313R, Mr. Farrell, BNSF Railway, Town of Springfield, Baca County.
Yep. Good morning, Commissioners. Alan Farrell with the Rail and Transit Safety Section for discussion here today on 25A-0313R. And in this proceeding, decision C25-0680 deemed an application filed by BNSF on July 21st, 2025 for an order authorizing it to close the crossing of County Road 15 in the statutory town of Springfield, Baca County, Colorado, complete, and granted the application. On September 29, 2025, BNSF filed an application for rehearing, re-argument, or reconsideration, or RRR, of decision number C25-0680. In BNSF's RRR application, BNSF notes that in paragraph 16 of findings of fact of the decision, that BNSF will be required to inform the Commission in writing that all work is complete within 10 days of completion, and that the Commission will expect this letter no later than October 10th, 2025. BNSF also notes that paragraph 3 of the order of the decision orders BNSF to inform the Commission in writing that all work is complete within 10 days of completion, and that the Commission will expect this letter no later than September 10th, 2025. As such, BNSF respectfully requests the Commission reconsider decision number C25-0680 and order that BNSF will be required to inform the Commission in writing within 10 days of completion, and that the Commission will expect this letter no later than October 10, 2025. And staff notes that paragraph 3 of the order of decision C25-0680, expecting a letter of completion from BNSF by September 10th, is in error. And if you're ready, I have a recommendation.
We welcome your recommendation.
Thank you. Staff recommends the Commission grant the application for RRR filed by BNSF. Note the paragraph 3 of the order of decision C25-0680 is in error, and change the previous order to expect this letter by October 10th, 2025.
Commissioner Plant.
I agree.
As do I, and that can be an ABC decision granting the RRR and correcting the paragraph. Thank you, Mr. Farrell.
Thank you.
Proceeding 21A-0141E, Public Service Company 2021 ERP, Mr. DeCenzo.
Good morning, Commissioners. Mitchell DeCenzo of your Commission Council. For decision today is whether to approve Public Services proposal for the public release of bid information associated with its 2021 Electric Resource Plan and Clean Energy Plan. As background, the Commission issued decision number C25-0181-I on March 18, 2025, in which the Commission granted Public Service a variance from Rules 3613I and J and directed the company to file a proposal addressing the public release of bid information within 2 weeks after completing contracting for all power purchase and bill transfer agreements. In compliance with that directive, Public Service filed its proposal on August 18, 2025. The company lists the documents proposed to be refiled as public information in its proposal, which include the 120-day report, related appendices, and comments submitted by parties and the independent evaluator from the 2021 ERP CEP. At the same time, the company proposes to retain certain project-specific pricing and LEC and LCC data as highly confidential. This information would remain protected until the conclusion of ongoing resource acquisition activities, which fall into two categories: projects initiated by the Commission via decision number C25-0587I, and the company's pending and forthcoming CPCNs for utility-owned projects arising from the 2021 ERP CEP. Public Service also proposes to post summary bid information on its website consistent with Rule 3613K. No party has filed a response to the company's proposal, and it is therefore unopposed. And I can pause here for discussion to proceed to offering a recommendation.
Now, we'd welcome your recommendation.
Council recommends the Commission approve Public Services proposal as presented and direct the company to refile the identified documents as public information consistent with its proposal and Rules 3613J and K. We also think it is appropriate at this time to allow the company to withhold the remaining highly confidential information, given the ongoing nature of the acquisition activities, and note that the company is committed to release this remaining highly confidential information within 2 weeks following the conclusion of the acquisition activities.
Commissioner Plant,
I agree with the recommendation.
as do I, and that can be an ABC decision. So thank you, Mr. DeCenzo.
Thank you.
Proceeding number 23A-0633G, Black Hills Gas Clean Heat Plan. Ms. Dundas, Mr. Mendelson.
Good morning, Commissioners. Lindsay Dundas of your Commission Council, and today I just have a few procedural items related to this Black Hills Clean Heat Plan. As you know, the hearing's set for October 27th, 28th, and 29th, which is next week. Yesterday, Black Hills filed a matrix which set 4.25 hours of scheduled cross. We expect a lot of Commissioner questions, but to not hide the ball on my recommendation, I suggest today that you vacate the last day of hearing, which is 10/29, as it's very unlikely to need all 3 scheduled days.
Commissioner Plant,
I agree.
as do I. And do you have other things on this one, Ms. Dundas?
Yes, Chair, just one short one. Last week, the Commission also received a motion from the settling parties requesting that the Commission extend the deadline for filing of a matrix and to set a deadline for filing of settlement testimony. We did receive settlement testimony last week, and we did receive the matrix yesterday. So obviously the dates requested have already passed, but I still recommend granting the motion belatedly so that it is clear the settlement testimony filed last week is part of the evidentiary record.
Commissioner Plant,
I agree.
as do I, and that can be an ABC order, Ms. Dundas, but I do have a couple comments I'd like to share. So with that, given some of the confusion that may or may not exist among the parties, and given that we've already decided this case once, rejecting the exact same settlement agreement that the parties just refiled, I just wanted to clarify my core interests and questions before the hearing so that the parties can prepare if they so desire. More specifically, Black Hills has raised a series of legal and policy issues in this case about the Commission's authority to require beneficial investments for a gas-only utility. As such, I'd like to explore having those legal and policy issues addressed now, in this case, prior to the next Black Hills Gas CHP filing. If these legal issues are going to be appealed to the courts, which it seems like the company may be intending to do, I think we should get started now and not wait 2 years. So at hearing, I'd like to explore seeing sufficient beneficial electrification investment in this case, certainly enough to constitute a case in controversy, so that these legal issues can perhaps start to get addressed now instead of after the next clean heat plan filing. So I don't think that needs to be in the order. I don't know if you have any additional comments you'd like to make, Commissioner Plant, but I just wanted to get that out before the hearing.
Yep, no additional comments.
Ms. Dundas, thanks. Proceeding number 25A-0220G, Public Service Company, Gas Infrastructure, Plan, Ms. Davis.
Good morning, Commissioners. I'm Kimber Davis of the Commissioners Advisors. Today, I'm seeking consideration of an unopposed motion for 2 public comment hearings to allow public comments related to proceeding number 25A-02220G, Public Service Company of Colorado's application for approval of its 2025 to 2030 gas infrastructure plan and other matters. The motion was filed October 2nd by the Colorado Communities for Climate Action on behalf of Natural Resources Defense Council, Rewiring America, Sierra Club, the Southwest Energy Efficiency Project, Western Resource Advocates, the Colorado Renewable Energy Society, and the Physicians for Social Responsibility Colorado. These joint movements ask that the Commission schedule the first public comment hearing mid-November and that the Commission schedule the second public comment hearing in January. The joint movements ask that at least one public comment hearing be conducted outside of work hours to encourage as much public participation as possible, and that either a virtual or hybrid option is acceptable. As a reminder, Rule 4552B3 requires that the Commission establish procedures for the proceeding that include one or more public comment hearings. Would you like to discuss this further, or do you prefer I provide a recommendation?
I think we prefer a recommendation.
Okay. Advisors agree that the public comment hearings would be helpful in the proceeding and that the joint movements outline a reasonable approach. Therefore, advisors find good cause to recommend the Commission grant the unopposed motion and schedule remote public comment hearings for November 18th, 2025 and January 20th, 2026, with both hearings being held in the evening from 5 p.m. to 6:30 p.m.
Commissioner Plant,
I agree.
as do I. And let's see, do we have a, we have another issue.
Would it be an ABC decision?
It will be, but we have another issue, I think.
Okay. Thanks.
Thanks,
Good
Ms.
morning,
Davis.
Commissioners. Lindsay Dundas, still of your Commission Council. In addition to the motion just presented by Ms. Davis, there's a second motion pending in this proceeding. On October 9th, Green Latinos filed a motion for late intervention. Green Latinos is a national nonprofit organization that convenes a broad coalition of Latino leaders committed to addressing environmental, natural resources, and conservation issues. They state that they have members throughout Colorado who are public service customers. Green Latinos, quote, respectfully submits that good cause exists for its late intervention. Green Latinos was not aware of this proceeding until recently, and during the relevant period, it experienced significant staff transitions, including the Colorado State Director being on sabbatical abroad and other Colorado-based staff being reassigned to national priorities in Washington, D.C. As of September 1st, Green Latinos has hired new personnel, and upon becoming aware of this proceeding, Green Latinos acted promptly to seek intervention. Green Latinos provided a statement from Public Service in its motion, which states that Public Service is in opposition to the late intervention. Public Service states it's opposed and highlights that Green Latinos may submit public comments to advocate for its policy positions in the proceeding. The intervention request is late by approximately 3 months, and good cause has not been shown to grant the late intervention. There's a robust set of parties in this proceeding, and additionally, granting late intervention at this stage of the proceeding would be prejudicial, unduly broaden issues, increase costs, end quote. For reference, the original intervention deadline was July 3rd, and answer testimony is due November 3rd in this proceeding. I'll turn it over for your discussion, or I can provide a recommendation.
Now let's have the recommendation.
Commission Rule 1401 states that the Commission may, for good cause shown, allow late intervention subject to reasonable procedural requirements. This legal standard affords the Commission ample discretion, so ultimately it's your call whether to determine if sufficient good cause exists to allow for late intervention. If you do allow intervention, I suggest you require Green Latinos to take the proceeding as it stands, since we're so late in the procedural schedule. However, I will highlight that it's likely too late in the procedural schedule with answer testimony due November 3rd for Green Latinos to provide something meaningful to the record with such a short time frame. And I'm also concerned that with less than 2 weeks, discovery may provide undue burden to the other parties. And just highlighting that we're 3 months into the proceeding as well as you make your decision.
Commissioner Plant, what do you think?
Well, I mean, I'm inclined to allow the intervention. I just want to make sure that it doesn't, uh, impact the other parties in the case, recognizing that it's so late. And Ms. Dundas, it sounds like that's your concern as well.
It is, Commissioner Plant, and Public Service states that they believe it'd be prejudicial and increased costs to let them in at this late hour. And I also have concerns that um, it really impacts the time frame to get discovery done for answer testimony. So that's my concern about the burden on the other parties.
Yeah, understand. Yeah, I guess I would vote to not allow the late intervention.
All right. So you're a no. So yeah, I guess Commissioner Plant, I'm struggling with the same thing, and uh, generally support greater intervention, but given the timing and the concerns about creating prejudice, um, and also the availability of the opportunity to comment, um, uh, I'd agree with Commissioner Plant and deny the intervention. So does that give you what you need, Ms. Dundas, for an ABC order?
It does, Chair, and I'll emphasize that while you're denying the motion for intervention, we just scheduled 2 public comment hearings where we would encourage Green Latinos to present their.
Yeah, I mean, I always find their participation valuable and look forward to hearing what they have to say, but 3 months this close to deadlines is tough. Thank you. Proceeding number 25A-0266E, Tri-State entry into SPP RTOS. Mr. Foreman.
Good morning, Commissioners. Wyatt Foreman of your Commission Council. As a quick reminder, this proceeding involves Tri-State Generation and Transmission Association's application for Commission approval, requesting a finding that the Southwest Power Pool Regional Transmission Organization in the Western Interconnection, or SPP RTO West, is a statutory organized wholesale market, as defined in Commission Rule 3752N, and that Tri-State's planned participation in the SPP RTO West is in the public interest. For your decision here is whether to waive remaining response time and grant the unopposed second motion for extraordinary protection, or MEP, filed by Tri-State on October 13th, 2025. On October 7th, the Commission held a public comment hearing at which parties in the Commission requested Tri-State provide additional information in the record, and Tri-State agreed to provide the additional information pursuant to appropriate confidentiality designations. On October 13th, Tri-State filed its MEP, in which it seeks extraordinary protection for 4 categories of documents and information it refers to as highly confidential information. The categories of information are internal and external implementation of costs and participation fees, full study reports regarding the benefits of market participation, Tri-State's commitment agreement with SPP, and detailed planning reserve margin analyses. Tri-State asserts the categories of highly confidential information include commercially sensitive information, and that disclosure of said information could cause irreparable harm to Tri-State's business operations, could hinder Tri-State's ability to solicit cost-effective resources, and could advantage Tri-State's competitors and/or contract counterparties if disclosed. Tri-State therefore requests the Commission issue a protective order that provides that access to the highly confidential information be limited to only parties to this proceeding and that are not competitors of Tri-State, and that for parties that are not competitors of Tri-State, access to the information be further limited to a reasonable number of attorneys and a reasonable number of subject matter experts representing a party to the proceeding. They request that competitors of Tri-State be defined to include the representatives and attorneys for other public utilities and their affiliates, independent power producers and their affiliates, and any other company and their affiliates with business functions that include the sale of energy or the development of facilities for the production of energy. And that individuals accessing this information, with the exception of the Commission and Commission trial staff, be required to execute the highly confidential NDA that is provided as Attachment A to the motion. Tri-State states that no party took a position on the motion, but also notes that Interwest, Holy Cross, and WRA did not provide a conferral response. And I'll go ahead and offer a recommendation here. Council recommends waiving remaining response time on the commission's own motion pursuant to Commission Rule 1308C and granting the unopposed motion. A party seeking extraordinary protection of highly confidential material under Rule 1101B must include a showing that the information for which highly confidential protection is sought is highly confidential, that the protection afforded by the Commission's rules for furnishing confidential information provides insufficient protection for the information, and that if adopted, the highly confidential protections will afford sufficient protection. Council believes the company's motion comports with the requirements in Rule 1101 and states good cause to grant the requested protections. Motion is unopposed, and council believes the requested protections are appropriate, reasonable, and consistent with the commission's rules and past practice. And I'll pause here for a vote or discussion on waiving remaining response time and granting the motion.
Commissioner Plant,
I agree.
as do I.
Thank you.
And that could be an ABC decision. 25A-0438E, Public Service Company ECA. Mr. Davis.
Good morning, Commissioners. I'm Ron Davis of the Commission's advisory staff. Each year in mid-October, Public Service Company of Colorado files an annual application for its electric commodity adjustment. The application narrowly addresses certain inputs to the calculation of quarterly ECA rates for the next calendar year. Specifically, Public Service requests approval of updates to the following components: the projected jurisdictional allocation factor, projected sales, the on-off-peak price ratio, and the class-specific on-peak ratios. Once the Commission establishes those components for the ECA calculations, the company goes on to file on or before November 30th a quarterly advice letter to update ECA rates effective January 1st, 2026. Accordingly, Public Service requests a decision on this application by mid-November, and thus wants expedited procedures, including a shortened notice and intervention period and a deadline for substantive responses to the application. Public Service states that to allow all interested parties an opportunity to review this filing, it served the application electronically on all parties who were in the company's Phase 2 electric rate case, and that was a case conducted in 2023. Public Service requests an intervention period of 7 days and a deadline of 26 days for responsive filings. I'll jump to a recommendation here, and that is to find good cause to set a shortened notice period with intervention filings due November 3rd and a November 7th deadline for substantive responses, and that would permit the matter to return to you at the November 12th weekly meeting.
Commissioner Plant,
I agree with the recommendation.
as do I, and that can be an ABC order. Thank you, Mr. Davis.
Thank you.
Proceeding number 25F-0335EG. Mr. DeCenzo, what does the F stand for?
That's a good question.
Uh,
This is a complaint proceeding, formal complaint.
Formal complaint. That sounds like a guess. Go ahead. Thanks.
Yes. So I will be presenting a recommendation regarding exceptions to recommended decision R25-0702EG filed by the complainant in this proceeding, Mr. Neville Rustamji, on October 10th, 2025. For background, on August 11th, 2025, the complainant, appearing pro se, filed a complaint against Public Service alleging, among other things, that the company improperly issued a notice of disconnection despite his account being current on payments. The complainant also requested a stay in the disconnection. Public Service responded by filing a motion to dismiss, asserting that the complaint lacks sufficient factual allegations to proceed. The assigned ALJ ultimately granted the motion in the recommended decision, which was issued September 26, 2025, noting that the complainant had not filed a response to the motion to dismiss. Subsequently, the complainant filed these exceptions, stating that he never received the motion to dismiss. Public Service filed a response on October 14, 2025, confirming that, due to an administrative oversight, the motion was never properly served on the complainant. The company therefore requests the commission reopen this proceeding so that the complainant has proper opportunity to respond to its motion to dismiss. And I'll proceed to a recommendation here, if that's okay.
That'd be great.
Given that the complainant was not served with the motion to dismiss and therefore was not afforded an opportunity to respond, we recommend the commission reopen the proceeding pursuant to Rule 1504B, and that the matter be remanded to the assigned administrative law judge to allow the complainant an opportunity to respond and for the case to proceed as appropriate.
Commissioner Plant,
I agree.
as do I, and that can be an ABC decision, granting the exceptions and referring it back to an ALJ for further consideration as you recommend.
Thank you.
So, thank you, Mr. DeCenzo. Commissioner Plant, anything else?
Nothing further. Thank you, Mr. Chairman.
Thank you, and I'll see you this afternoon.